welcome back to the Hill Law Group podcast. I am Meredith Hill. I am the owner and principal attorney at the Hill Law Group. We are an estate planning firm located in Bethesda, Maryland. And today we have another attorney at the firm, Ericca Pearson, with us.
Hi.
Yay. So today we are going to talk a little bit about what exactly estate planning is and what happens if you don't have an estate plan. But first, Ericca, I want you to introduce yourself a little bit and maybe tell us why you got into estate planning.
Like Meredith said, I'm Ericca Pearson. I have been practicing law for a long time. I started at a big firm and lost my mother when I was at a big firm. And when my mom passed away, it was devastating, not just because we lost her, but there were lots of legal things that were involved in losing her. And me being the lawyer in my family, everyone looked to me to know what to do, and I did not know what to do. There are lots of paperwork, lots of different things that you have to fill out in order to manage assets after people pass away, even when they're married or not. So lots of times I think people think if I'm married that your spouse takes care of everything. And generally that is what happens, but every case is different. And so it just made it very important to me to help other families to get through the process. And it has really helped with my grieving process that, I've been able to kind of get through the things that happen with the loss of my mom by helping other families not have to endure some of the things that we endure. And putting together the estate plan is really the thing that prevents all of the things that can come, with losing someone and grieving them at the same time. So that's really what brought me here. And I just continue to love to educate people about what would happen if you pass away, what would happen if your parents pass away. And it's when you have the luxury of time, you can think about, what I want to do with all this stuff. It is the best thing to have to do. And so it just, it's very exciting to me. I know it sounds like it's not the most exciting topic, but it really is for people to just think about what would happen. And, let's think about it for that hour or so that we talk about it. And then you get busy living, not thinking about debt, but that there is a plan in place on where all of your assets go after you pass away. So that's kind of what brought me here. Thing that still gets me excited. I love estate planning. It is, I love it.
I love it too. That's why we're here. That's why we're estate planning attorneys. So did your parents have an estate plan?
My parents did not have an estate plan. And crazily enough, the way that it started is my parents worked together and they were on planes probably 48, 49 weekends out of the year. And they would say, what would happen if the both of us passed away? And I recognized that they needed something in place. So I got this book. That I got someplace like at Barnes and Noble where it lists all of the things that you need to do, kind of a very rudimentary estate plan. And they never got around to filling it out. So I knew that there was, and maybe that's kind of where it all began, because I did find that book after my mom passed away, and I was kind of upset that she started it and didn't complete it. Mm-hmm. So they did not have an estate plan when my mom passed away. When my father passed away after my mom, he has since passed away 3 years ago now. He had most of the stuff in place. But there were some decisions that were tough for him. Mm-hmm. And lots of times I think people, and we see this in our practice as well, when there are difficult decisions for people to make in life, they feel like maybe they will work themselves out after they pass away. And they do not, and they have not. But the experience that I've had with both set of parents, I feel like it's a bookend. Their bookends have made me, it's just put this exclamation point on why you definitely need an estate plan. Mm-hmm. You do.
Yeah. And I feel like people fall into that same set of situations of they get some materials together, they have the intent to do it, but then they never actually do it because one reason or another. So they are either a life event occurs or just life in general happens and you look up and it's been 10, 15 years
Right.
and nothing has been done. And
Yep.
so unfortunately, a lot of times people come to us in a state of crisis or emergency. And we try to prevent that from happening with estate planning. And as you like to say, estate planning really helps you not only rest in peace, it
Yeah.
helps you
Live in peace. Yep.
So with that, let's dive into exactly what estate planning is. So I feel like, and I'm sure you might agree, it's kind of the word estate always is a misconception because it makes you think that you have to be rich in order to start estate planning, but that's not really the case at all. You just have to be 18 or over
and have stuff in your name.
and have stuff in your name. And with that, like estate planning is not only planning for what happens after you pass away, it's also what happens if you become incapacitated, who's going to still pay your bills, who's going to sign on your behalf, who's going to pay your taxes for you, all of those things. Also deals with your healthcare, and all of these issues that you don't really think about unless it becomes an issue.
Right.
So as planners, we like to plan for both expected events like death, but also unexpected events that we hope never happen. But if they do, you have a plan in place. So you're again living in peace.
So the thing that I also think is important to note is it's hard to put a weight on each estate planning document. So there are lots of documents that we include in your estate plan. So you'll hear terms like trust and will and living wills and power of attorney. Your set of circumstances really makes the value of those documents go up or down. So you talk about if people are suffering from, they become incapacitated, suffer from dementia, and maybe live decades, without passing away. You need to have that power of attorney in place so that somebody can take care of you, or have a trust in place so that people can take care of you while you are living these long periods of time. So let's say I have a family member right now who is not married and who is suffering from some severe dementia and didn't put documents in place before she became severe. And her children are having some issues because there are accounts that they need to get into, and there's some money that they need to get to be able to access. And they're not really able to do that because they won't talk to the kids because they weren't able to put these documents in place prior to. And so what they're probably going to have to do is go through a guardianship proceeding to be able to get the authority to do the things that they need to do. And what a big thing about what we do is we want to be preventative. We want to put all those documents in place that once you get to the place of maybe you're suffering with dementia, or maybe you are, in a car accident and you're in a coma for a long time. None of us has this crystal ball to know what path our lives are going to go down and know which documents we're going to need, which are going to be the most important to us. So it's important to put all of those documents in place to prepare for all of the what ifs.
Yes, the what ifs, the what ifs. So let's talk about the different documents that should be included in everybody's estate plan. So, and as we go through the podcast, we'll have different episodes on different documents, and we can dive more in depth into them. But I think it's important for this conversation that we at least have an intro into what some of these documents are. So the first document that people really think about is that last will and testament. And that is the most popular one. It deals with what happens to your property after you pass away. But this document's also important because it also, if you have minor children, it is the tool that is used to help determine who will care for your kids if something were to happen to you and your partner. So we want to make sure that if you have children under the age of 18, that you specify who will be their legal guardian. Because if not, it'll be left up to the state, wherever you live. And what's good that we talk about often is that when your kids are young, because I have a young child, that you make the decisions for them. But as they get older, because Ericca has a 14-year-old son, that you can have the conversations with them.
They're more involved in making some decisions, and it is important. But definitely if you have minor children, you've got to have a will in place. That is, and people think that that's the end all document, but there's some other documents you need to put in place. The one thing I always like to point out though about the will, you want to put that in must if you have a minor child, but there's this process called probate.
Oh, yes.
Probate is this court process that is a lot of red tape is involved, lots of documents, lots of costs that could be involved. And what most people don't know is that there are two ways to guarantee you going through that probate process. That's not to have anything at all, not to have any will in place, or just to have a will in place. So the will kind of guarantees that you're going through all this red tape, all of this lengthy court process where there is an auditor that's in charge of all the things that you're doing with the loss of a loved one. So you want to definitely seek out an estate planning attorney to give them, to walk through your situation to determine if the will is the best plan for you. Because the will could work for you, but you want to be sure that we are utilizing all of the documents that make sense for your scenario, so that we're not just doing a will and that's all you do. There's a lot more involved in estate planning than just putting together a will.
Yes. A lot more involved. And so like in our process, we have you fill out a questionnaire beforehand. I'm sure other attorneys, so good estate planning attorneys will have you fill out a questionnaire beforehand so they can get a really good snapshot of your life, your assets, your goals and objectives with estate planning. So it's a little bit more than just a will. Sometimes it really is like, but these are rare times where people just only need
a will.
I mean, that's a rare occasion, but it does happen. But some of the other documents that we like to also.
Well, let's also talk about this with the will, the naming your guardian and also indicating whether you want to be buried or cremated.
Oh, yes.
So those are the two big things with the will. And where your stuff goes, that we don't want to just kind of push that under the rug, but those are the three main things with the will. The biggest thing and your most treasured asset going to be your kids. So we want to be sure that we have the will in place so that we know who's going to be the guardians of your children. Then whether, where my stuff goes, you do want to be involved in that process, as opposed to having the state say, here's who should receive all of your assets and, how much they should receive. You should really have a say-so. And where your assets go. And then that third thing, whether you want to be buried or cremated. So those are kind of the three pillars. I mean, there's a lot more involved. We're trying to simmer it down as much as we can. But those kind of the three pillars of the things that you need to think about when you're putting together the will. So those are the big things with the will. Yeah,
I agree. And in a little bit, we'll talk a little bit more of what happens if you don't have a will and what that looks like. Or any of these estate planning documents. Right. But another document that we like to prepare that is a good foundational document is your power of attorney document. This document allows someone to step in your shoes and act on your behalf if you are physically or mentally unable to do so. So they can sign on your behalf, they can file suit on your behalf. They can open a bank account on your behalf. They can literally do what you do. And this is a great option to have just for peace of mind. But with that, we want to make sure that when you are selecting someone that's going to be your power of attorney, that you're selecting someone that you trust with this power, and that's going to take it seriously. And just as a side note, because we get this often, the person does not have to be an attorney to be your power of attorney. No. So we get that often of, Meredith, Ericca, do we have to get an attorney to serve in this role? No.
It's a term of art.
Yeah, it's a term of art. It can be your mom, dad, husband, wife, neighbor. As long as they're over the age of 18 and of sound mind, they can serve in that role. But again, make sure that they are trustworthy, because we've seen situations where people take advantage of their powers, and we don't want to do that.
And we also see a lot where parents feel like they have to name their adult children as the powers of attorney. And specifically, maybe in that age order, you don't have to do that either. That if your youngest child is more responsible or the best person to serve as your power of attorney, you can certainly list that youngest child as your power of attorney.
Yeah.
But you don't have to list children. So just like Meredith was saying, it can be a very good friend of yours. It can be a neighbor. It can be your sibling. Whoever you feel like would make the most responsible decisions in it when you could not, when you cannot. That's the person that you should select. And I like for my clients to be very selfish when it comes to those scenarios, just because. So we talk about living in peace. The power of attorney document is one that you have to kind of live through. So power of attorney it functions when you are alive. When you pass away, you are no longer someone's power of attorney. You want somebody who's going to be trustworthy and do the things that you need them to do. So let's select the best person for you and in your life. And you don't care about somebody feeling slighted or mad, because you're going to be the one that's mad if the wrong person is in that scenario. So choose wisely.
Choose wisely. And this is another note, like husbands or people in marriages don't have to choose each other. So just think about that.
Yeah. And most times we do have our husbands and wives.
Yeah, most of the time.
Like I would say 90% of the
Yeah.
time. But there have also been some scenarios where that was not the right person.
Correct.
For whatever reason.
Yeah. Yeah. For whatever reason, it's not the right person. And that's fine.
Yeah.
But yeah, be selfish with it.
Yep.
Another document that we prepare is your advance directive, also called a medical power of attorney, which allows you to nominate someone to act on your behalf and express your health wishes to your doctors if you are unable to express those wishes for you. So if you're in a coma, for example, and the doctor needs to decide whether or not to do surgery or do something else, you will have had already nominated someone to make this decision. And this does not have to be the same person that you've nominated for your power of attorney. It could be someone different. And again, with all the we talk about, we want to make sure that we're selecting someone that's really going to have the capacity to make these decisions, because the medical decisions, that can be very tough and it can be very emotional for that person. So we want to make sure that the person that we're selecting has the capacity to do it, that's going to follow your wishes as well and not be selfish with it.
Right. Right. And again, that's another document that you have to live through, another document where, this functions while you're alive. And I also think it's very important to have conversations with people who hold these roles in your life. So specifically with that healthcare role, it feels a little more personal because we're dealing with your actual body, your healthcare. So I know sometimes talking about these estate planning things, you have to maybe get into a frame of mind where everything is not like gumdrops and lollipops, but you do need to talk to people about, here's what I want done if I were ever to be in, a certain state. So I've had this conversation. In fact, the person that I have selected is not a family member of mine. And I've done that because I believe that the person who I would select would be too emotionally involved, and it would be a lot for this person. The person I've selected is a very good friend of mine, but she's a nurse, and there are some decisions that I've made that she doesn't necessarily agree with, but she's going to make them because it's something that I feel very, very strongly about. And I'm an estate planning attorney. I talk about it maybe overly. I talk about, here's what I want done. But I want to encourage people to begin having these conversations with your family members, with your children. Again, it does not have to be this extensive conversation, but they need to know, if I am in a coma and they put me on life support, what your wishes are. So you'll have that in writing, but you also want to kind of give them the backstory on that so that they know when they're making those decisions, it's not just because of, whatever. It's because I endured such and such and so and so. And I feel very strongly about either being on life support or not being on life support. So I think it kind of does make it easier for them to make the decision because they kind of know the backstory because you talked about it.
Yes. And speaking of life support, that leads me to my next document, the living will. So the living will is a document that we use to deal with end-of-life care if you are in a persistent vegetative state. So if you are brain dead, and the doctors have signed off that, they don't think that there's any chance of you coming back from this or having.
Are you living without being on?
Yeah, living
machines.
Without being on machines, correct. And so we create this document so you can express that, if whether or not you want to be on life support, if so, how long, and what type of treatment you would want to receive. And so I find this to be one of the most personal documents because you are literally giving life and death in this document, your life and death in this document. And everybody's position is so different that we talk to.
It is.
And you just never know. So like I was doing I was doing my mother's living will, and I thought that she would want to be on some form of life support until I died, and then she could die with me. She didn't like that idea, and so she said that she never wanted to be on life support. And so I acknowledged that, and I put that in her document. So God forbid that ever occurs, I would know. Let me knock on some wood.
No.
God forbid that ever happens, I would know, like, that's her wish, is not to
But
be
that's important to know.
Yeah.
So you would have probably, so here's what generally happens. As a child, you don't want to, let's call it what it is, pull the plug on your mom. So you're probably going to have her on life support and keep her here for as long as possible because you want her alive. But that's not what she wants.
No, it's not what she wants. And so,
but knowing that, I'm telling you, it's going to be the best gift ever.
Oh yeah. Yeah. If I ever have to do that, I will know, like, this is what she wants. But we've seen situations where people are left on life support for decades. And because loved ones just can't emotionally let go, which is understandable.
Absolutely.
But we don't know if that person that is on life support, if that was their wish. So we find this document crucial as part of your estate plan.
Yeah.
And we hope and pray that you never have to use it. But if you do have to use it, again, you can rest peacefully knowing that you selected the right person to act on your behalf, and they're going to follow your wishes when it goes to your living will.
So the other thing that I think is so interesting with our living wills is that we also will put in this time frame, saying, if I have to be on life support, how long do I think is long enough? How long do I think is too long? And the reason I think that is important is just because, again, it's very personal. But I find that there are no two clients that are the same. So there are people who want to be on for 7 hours, and then there are people who want to be on for 2 years. But I think it's important, again, to really talk to that person, to really help them to kind of work that out, to know, I've just recently redone my living will. And I think it's because I talk to people and just start listening to what they want, what they don't want. And it's just personal. I would not personally, I don't want to be on life support at all. But I recognize that being on life support for a little bit of time is helpful to your family members and helpful to those you are leaving behind if they feel the need to see you or spend some time with you while you're still here. And so my time has been shortened, but some people may keep me on as long as possible. I hear about people coming off of life support and coming back and living full lives. You should have the ability to say that, as well as keep me on for 6 hours. So yeah, I think it's important to just note that. And it's just, to this day, I love doing that with couples. Couples generally don't have the same thought process. So either one of them will say 3 days and other will say 2 years. And it's just interesting, I think.
It's very different.
Yeah.
Couples, it's yin and yang.
Yes.
Opposites attract.
It does.
Yes.
I it's part of the process that we don't kind of like talking about, because it is kind of you having to think about something bad. But I think it's very interesting to get the take. They're never really like, oh, you're doing 20 days. I'll do 20 days too. So
yeah, I concur.
Yeah. Very interesting.
Okay, so our last but certainly not least, and we're not going to dive too into this because we can do several episodes on this document, but it is a trust. A trust. A trust, we love trust here at the Hill Law Group for a variety of reasons, but a trust, similar to the word estate, has a interesting misconception because people think of trust fund babies and being these rich, wealthy people that have yachts and send their kids off.
Like those are the only people that have trusts.
Yes, and vacation in the south of France every summer. Those are the only people that can have trust. But no, trust.
Absolutely not true.
Yes, trusts are an excellent instrument to use to distribute your assets after you pass away, or still have them managed while you are incapacitated. And it essentially takes your assets out of your personal name, so like Meredith Hill, into the name of your trust. So if I had a trust, individual trust, it would be the Meredith Hill Living Trust, for example. There's a variety of different types of trust, and we can speak on them in different episodes, but we're just going to just touch ever so lightly on just like what a trust is, and then what we're talking about in this term, in this concept, is just a revocable living trust. So we like trust because that probate process that Ericca talked about before is horrendous, and it's very lengthy and time consuming and expensive. Trusts allow you to bypass that process as long as your trust is set up properly and the fund, and you retitle assets into the name of the trust. It's also a private process, so you don't have to file anything with the court. You don't have to file your trust with the Register of Wills of your jurisdiction or your state where you're living in. People won't be able to see your trust. It is just a wonderful tool. And my favorite thing is that you're able to really have control beyond the grave after you pass away. And that's a really great tool to use if you want to leave assets to your minor children or grandchildren. So we have a bunch of clients that have minor children and are also have grandchildren, and they want to leave some money for them to take care of them.
So, and one of my favorite things about the trust is, specifically if you have minor children, is that we talk about how your children are taken care of from the time that they're living now. So let's say, for instance, my 14-year-old, until he reaches what age am I looking at? Am I looking at 18? Am I looking at 22? We want to make sure that his health, education, maintenance, and support are taken care of while he's a minor. And then you talk about what happens to what I think most people consider his inheritance. Does he get that inheritance in full when he turns 22? Can I kind of space those out? I'm in love with that process. The fact that you can actually space out how your child gets their inheritance. And it's just important. I think that, and we find this as well, that our clients, it's just a different thought process. If you know you have children that at 18 could get this lump sum payment of $1 million and do what they should do, and we have clients like that. But if you know your kids are not that kid and they need to have it, maybe they get it in chunks. Maybe we split that in 4 over the course of their adulthood. I think that is one of the biggest things that I love doing with our clients, just making that plan for their children. So you think, oh, it's not going to be them just getting this big chunk, that this is going to last throughout, a portion of their lifetime. So it's very important to do that. And it's very specific to every family. And so that is really where we're kind of tailoring this document to your family and making it fit your family. Unlike, so my document may not fit your family. It may be a very well-planned document and make sense for us, but we couldn't take my document and put it on your family and have it make sense. So that's the part of the process that I love that we do with our clients, is that we actually plot, plan, figure out how we can make it work specifically for them.
That is why it's important to use a professional estate planning.
Absolutely.
Because everybody
to LegalZoom. Oh, I didn't say that.
Don't use LegalZoom. Please don't. Yeah, so I just had to say that because we have seen people try to use LegalZoom and it's just kind of
or whatever
software.
I do that lots of times. I know you get up late at night and you're trying to figure out I'm with my medical issues and you're Googling everything. Google can be your best friend or not. Yeah, sometimes you got to let the professionals
Let the
handle.
professionals do it. Because if you go on WebMD about all your stuff,
And
you're
I'm
not-
diagnosed, right?
Yeah. Yes, you have one foot in the grave,
Right.
according to WebMD.
Oh
But
my.
really, you need to drink some water. You're dehydrated.
Same can
but the
apply
same-
to estate planning.
The same as with
You
estate
figured it out.
Yeah.
And really the big thing to know is that if you have put a plan in place where you think you've crossed every T and dotted every I, and there's this gaping hole in your estate plan, the time that they will find out is after you've passed away and there's nothing that can be done about this. And so you want to be sure that you put the plan that makes sense again for your family, and that we've thought about, because our job is worst case scenarios.
Mhm.
So a lot of times we'll hear clients say, I never thought about that. It's like,
Yeah,
that's what we're here to do.
that's what we're here to do. So to wrap up, let's talk about what happens if you don't have an estate plan. I'll toss it over to you, Ericca.
Okay, so basically the fancy term that you get to that is it's called dying intestate. So these intestacy laws will apply if you pass away without a will in place. So lots of times I say this: if you don't take the time to put an estate plan in place, the state will do that for you. There are just laws that are in place, and they're specific for every state. If you die with a spouse and children, then there's a certain way that your assets will be distributed. If you pass away and you're single and you have children, you have siblings, every state says it provides a law on how your assets are distributed. And that may work. You may luck out and everything goes to all of the people that you want them to go to. But what you do, the risk that you take when you die intestate is, number one, you give control over the state to create your estate plan. And the second thing you do is that who's to say the right person is the one who's named the personal representative to manage your assets? So that's the first thing. And then secondly, what happens if somebody in your sphere or in your family is getting a portion of your assets and you absolutely don't want that person to get that money, or you absolutely know that this person is going to squander all of the things that you've worked hard for? So, dying intestate is really the thing that we want to try and avoid.
Mhm.
We are doing all of these, spreading and educating people to just, if you don't do anything, do something. So doing nothing, not having an estate plan, is absolutely the wrong thing to do. Figuring out what to put together, whether it be a will, whether it be a trust, we want to make sure that you have done something. But you definitely want to be the one who says what my estate plan is. So let you have the control, and you be the one who indicates what estate plan should be in place, as opposed to kind of turning that over to the state to say, have at it.
Mhm.
Whoever you want to get my stuff can get it.
So I also want to address a question that we get often, which is another misconception, is if you die without a will, does the state take all of your stuff and all of your money?
Generally not necessarily,
No.
but there can be some scenarios where they can take your money, and you definitely don't want to be in a situation, at least I wouldn't, where you've worked hard and then your money goes all to the state for whatever purpose they want. And then it's important to know, so if you live in Maryland, Virginia, or whatever state, you have to become familiar with the intestacy laws. Nobody wants to know about that. If you're going to do all the research to figure out what the intestacy laws are, go ahead and get an estate planning attorney to put together your estate plan. But it's important to know, like, lots of times we'll meet with clients and they will tell us that there are certain people that they definitely don't want serving as their personal representative. They definitely don't want this person getting any money from their estate. And what we would say to them, well, if you don't have anything in place, that sibling may get that money because you're not married and you don't have any children. Your brothers and sisters are going to split that money, and you're going to have to be okay with that because you didn't put anything in place. So
that's important to note that intestacy laws only look at your family members. It goes down your family tree. And a lot of times as you get older, you're still close to your family, but your friends become your family. And so you may want to leave some items to your friends. If you are in a long-term relationship,
we have that a lot.
Yes,
That
we have-
people who are in long-term relationships who have done everything but
get married.
get married.
Yeah, for one reason or the other. In the eyes of the law, that's just your friend. And if you were to pass away without having an estate plan in order, that person would get absolutely nothing. So we want to prevent that from happening, and want to make sure that you have peace to know that whether it's an unexpected situation or expected, that you are in control.
Mhm.
And that's what estate planning really gives you is
Mhm.
so I think that wraps up our little episode for today on what is estate planning and what happens if you don't have an estate plan. And we are attorneys with the Hill Law Group. We are located in Bethesda, Maryland, and we service clients in Maryland, DC, and Virginia. And you can follow us on Facebook and Instagram at Hill Law Group. And you can email us at info@thehilllawgroup.com or visit us online at www.thehilllawgroup.com. We will see you on our next episode. Bye.
Bye.